Well, good morning, everyone, and thank you for attending today. Today is one of the series of Brodie's webinars, and we're going to be dealing with group proceedings or class actions as they're known in other jurisdictions. If I can introduce myself, I'm Joyce Cullen, one of the partners in our commercial litigation team, and I'm joined this morning for the webinar by my colleague Craig Watt, who's one of our senior associates and a solicitor advocate in our commercial litigation team. Today, Craig and I are going to cover three broad areas in relation to the new group proceeding rules in Scotland. I'll start with a bit of background to the rules. Craig will then look at some of the specific changes to the court proceedings, and we're going to look at the likely impact on the proceedings for those who are litigating. And then we'll consider what the impact on clients is likely to be and steps which organisations should perhaps be considering taking now. So, first of all, what are the long-awaited rules? We have been waiting for them for some time. As you may know, other jurisdictions, particularly in England and Wales, have had class actions since about 2020. But for the first time in Scotland, then, groups of two or more people with the same or similar related claims will have a way to raise proceedings together in a single action in the Court of Session. As I said, for some years there has been a bit of pressure for class actions or group proceedings, as they're called in Scotland, to be allowed here. And there was almost legislation that would have covered simply financial services litigation some years ago, and we were optimistic that that would break some ground in Scotland, but unfortunately that legislation was dropped for lack of time when a general election was called. So in practice, for many years now in Scotland, we found, I suppose, a way of working around not having these rules to allow separate actions to be able to run in tandem with the agreement of the parties and the cooperation of the judge who's managing the case. So for example, in personal injury claims, such as the vaginal mesh claims, which have been running for a year or two now, where parties have been able to choose maybe test cases to run and put all the others on hold. And in the commercial litigation context, certainly a case that I've dealt with in the last couple of years relating to a number of pension schemes where there were similar facts, but several pension schemes all operated by related employers. And the parties agreed with the judge that we could run the cases in tandem with one court hearing and one decision being issued, but dealing with the separate facts found for each of the 6 cases. But it's fair to say, I think, that there has been a demand for a proper system for managing these cases, and we now have it in Scotland. So, handing over to Craig, I'll ask the question, how will the new group proceeding rules change things? Will they improve on the ad hoc arrangements we've had up to now, Craig?
Hopefully, Joyce. Yes, just in relation to the changes, well, as you'll all probably be aware, the Civil Litigation Expenses and Group Proceedings Scotland Act 2018 is what has introduced the possibility of group proceedings in Scotland. And as you'll probably also be aware, there's some new rules come into force at the end of July this year. That's through the Act of Sederant Rules of the Court of Session 1994 Amendment, Group Proceedings 2020. And that introduced Chapter 26A to the rules of the Court of Session. So what are these new rules? Well, firstly, dealing with how you bring group proceedings, which most of us will be interested in. Group proceedings can only be brought in the Court of Session. Before an action begins, 2 determinations must be made by the court. The first being, is the applicant suitable to represent the pursuer's group? And the second, should the action be brought as a group proceeding? And both of these applications are heard before calling. So, looking firstly at the application to the court to be declared a representative party, that's covered by Rules 26A.5 to 8. The individual doesn't have to be a member of the group, but if they're not a member of the group, the applicant must state the capacity in which they are applying to be a representative party. Details of funding arrangements don't need to be disclosed, but what we have to anticipate is that the Court Reform Scotland Act 2018, that sets out various requirements for disclosure of third-party funding in civil litigation. Those provisions aren't yet in force, but I think it's coming down the line, so we have to be mindful that that may oblige parties to disclose those funding arrangements. But when an application to be a representative party is lodged, it's put before a Lord Ordinary on the first possible day that they can consider the matter, and that they'll be considering it for an order for intimation and service of the application on the defender or anyone else that the Lord Ordinary thinks fit within a short period of time, within 7 days is a default, for advertisement as the Lord Ordinary thinks fit, and to allow any person upon whom the application has been served to lodge answers. Now, an application to be a representative party does require the applicant to have taken steps to identify and notify all potential members of the group proceedings or the intended group proceedings. And details of that advertising will have to be disclosed to the court and included within the application. We'll all have heard various radio advertisements and such over the past few months, trying to collate members to various group proceedings that are intended. When the judge is considering whether an applicant will be an appropriate representative party, the judge has to consider a number of things. They will have to consider the special abilities and relevant expertise of the applicant's interest in the proceedings, whether there would be any potential benefit to the applicant, financial or otherwise, I suppose, confirmation that the applicant is independent from the defender, demonstrate that the applicant would act fairly and adequately in the interest of the group members as a whole, ensuring that their interests don't conflict with that of the group. And finally, to demonstrate a sufficient competency to litigate the claims properly as group proceedings, including financial resources to meet any expenses awards. Now, the Court of Session, or the Lord President, has issued a practice note touching upon group proceedings. And in that, the Lord President states that the application should address all of these matters in detail, and it simply won't be enough just to repeat the wording of the rules. So you're going to have to detail, in particular, in respect of the advertising elements, what particular steps you've made to try and notify potential members of the group. Moving on then to consideration of the permission stage to bring the actual group proceedings. So a representative person may apply for permission to bring group proceedings. It is likely, I anticipate, that this application will be considered at the same time or advanced at the same time as the application for permission to be appointed as a representative. But I suppose it needn't be that structured that way. The rules concerning the application to bring group proceedings, that's 26A9 to 13. An application requires to be made in the form 26A9. You're required to lodge a copy of the proposed summons, the group register, which we'll touch upon later, and all relevant documents to be considered when deciding upon the application for permission. In response to this application, again, the Lord Ordinary will make orders, or will have to be addressed on making orders for intimation and service, advertisement, and for answers, in much the same way as the application for the representative party. After the deadline for lodging answers has passed, the court will deal with the application within a short period of time. I think it's anticipated 14 days. And the Lord Ordinary can deal with it in one of the following ways. The Lord Ordinary can either grant permission without holding a hearing, which I think would be unlikely if meaningful answers are lodged. It could require any party to provide further information before making an order, or fix a hearing on the application and any answers lodged. And at that hearing, the court will hear parties, and the court must then consider whether or not to grant the application for permission in full or subject to any conditions, or to refuse the application. Now, crucially, what is the court considering when determining whether or not to grant permission to bring group proceedings? Well, the pursuer must prove that all the claims raise issues of fact or law similar to each other, that the representative party has made reasonable efforts to identify and notify all potential members of the group, that there's a prima facie case, that, and crucially here, it's more efficient for the claims to be brought as a group rather than individually, and also that the proceedings have a real prospect of success. Now, in contrast to consideration of the decisions on whether or not to allow an applicant to become a representative, the decision to grant permission to bring proceedings can be reclaimed against as of right by either the applicant or the defender, whereas in relation to the application to bring representative proceedings, the permission of the Lord Ordinary would be required. So, moving on to the group register, I touched upon that there. Now, what has been set out by the Lord President in relation to the group register in the practice note is that it's crucial to the recording of the group. It's described in the practice note as being central to the proceedings, and it will be considered at every hearing. Now, as I set out before, the group proceedings are opt-in, which means that everyone in the group must expressly consent to being included in the claim. The pursuer must lodge and serve on the defender a group register listing all group members, and that must be updated as soon as possible when a member joins or leaves the group. And it's worth noting that until a proof is allowed, members can be added merely by lodging and serving on the defender and or lodging with the court and intimating on the defender an amended group register. Now, that might have implications in terms of prescription, which we'll touch upon later. But the practice note emphasises the importance of careful management of the group register and also sets out how it's to be lodged and intimated in terms of electronic copies. Touching then upon prescription and limitation, well, it's crucial to the parties and all the group members that the group proceedings operates well. And that is particularly so in relation to consideration of prescription and limitation matters. The administration by the representative party or the agent for the representative party requires to be conducted in terms of the rules, and that the group register is a key part of the success of that procedure as identified in the Lord President's note. Now, in terms of when prescription bites, the service of the group register or amendments to it under the rules amounts to commencement of the proceedings in respect of those named in that register. That date will therefore be the significant date for prescription and limitation purposes. Merely serving an application to be appointed as a representative party will not suffice. So, how are group proceedings going to be handled by the court? Well, the practice note from the Lord President certainly indicates that the procedure is going to be roughly modelled on the commercial court practice. It allows for early intervention, case management by the court. There is arrangements being made to ensure that, save in exceptional circumstances, the same judge will preside at each and every hearing. And there's also an expectation that parties will instruct the same counsel or solicitor advocates to appear at each hearing. The pleadings should be in an abbreviated form, and generally the proceedings will form the structure as set out on the slide. That is preliminary hearing, case management hearings, and then a proof or a debate. So it roughly follows the commercial court proceedings that we'll all be familiar with. That's a brief canter through the rules and the impact it's going to have on how we conduct these types of proceedings. And I suppose the point that you might touch upon now, Joyce, is, do you think the courts are likely to face a tsunami of claims under the group proceeding rules?
Well, thanks, Craig. That's very helpful. I think a tsunami is probably going a little too far, but certainly it's clear that the aim of the new rules is to make it easier for groups of individuals to bring their claims to court. So it does seem likely that we will see an increase in the number of cases proceeding in the Court of Session. We've not, of course, yet seen an application for group proceedings actually being approved by the court, as I understand it. And from what you've said about the rules and from our observation of what's happened so far with the cases that have been raised, it does seem that it might not be entirely straightforward for groups of litigants to have permission granted. The practice note, as you've said, which is issued by the Lord President recently, makes it clear that even to satisfy the court that an applicant is suitable to be a representative party is going to require quite a lot of work to be done up front with full supporting documentation. So, for example, although I think you said you don't need to produce evidence of what the funding arrangements actually are, you will have to satisfy the judge that there is adequate funding in place to run the case for to the end, and also, I suppose, to meet the potential expenses of the other side if the case is run and lost. So I can see that up front there's quite a lot of work to be done for the pursuers and the solicitors who want to be appointed as the representative party. So I don't see a tsunami of claims coming in until they have their act together on that. Secondly, of course, the practice note and the rules indicate that full documentation has to be lodged when the application for permission to bring the group proceedings is actually made. And as I think you've mentioned, it's open to the judge to refuse to allow the application on quite a number of grounds. And one of them, is the one that you highlighted, I think, is that it hasn't been demonstrated that the proposed proceedings have any real prospect of success. Now, on one view, that's actually quite a stiff test. And we don't know yet how the courts are going to interpret that rule and how easy or difficult they're going to make it to overcome that test. But we were thinking about, what would be open to defenders who are faced with group proceedings applications being made, and the sort of things that they might want to argue to prevent that from happening. And I can certainly envisage that we will have some cases being brought where the defenders will take a view that they should have a go at arguing at a very early stage in the case that there's not really any real prospect of success. And I can envisage that being quite a substantive hearing. So where normally in commercial court proceedings, that sort of argument would be at a much later stage, so at the stage of a legal debate, whether or not certain parts of the case had any prospects of success, etc. I can envisage that there might be some defenders who will bring that point front stage at a much earlier stage. And I think the other point which you mentioned, Craig, is that an order to allow or to refuse group proceedings can be appealed against, so using the reclaiming procedure, without leave of the court. And I think we might well find that there will be defenders who will test that. So whether or not the group proceedings order is allowed or whether it's refused, I can see the unsuccessful party at that stage thinking about contesting it. And so, again, to answer your question, will there be a tsunami? Well, it will depend on the attitude of the court and how easy they make it or how difficult they make it for pursuers to get over the hurdles. I suppose that the other issue is, what sort of organisations do we think will be faced with those types of actions? And when we've been discussing it in our group, it's really potentially a very large number of organisations. I mean, anyone who is providing employment or services or goods to substantial numbers of individuals or perhaps small businesses, where they would up to now have been those individuals be reluctant to spend money and time on litigation, especially when the sums perhaps weren't enormous. I see that if those groups can get together, perhaps using a trade union or a consumer body to assist them to get organised, or indeed, firms of solicitors who are looking for that type of work and to assist parties to bring them, I can see that might well encourage litigation which just wouldn't have seen the light of day before. So I would say those who are running hotels, house builders, those running large groups, say, of restaurants, providing education services or student accommodation, even independent schools. I can see that if there are large numbers of people who have a similar or same type of anxiety, then they might well consider bringing proceedings. So, the bottom line is that the group proceedings are supposed to remove some of the barriers to pursuers bringing actions to the court. There will be, I suppose, less exposure to expense for them, and we can maybe think about that. And it does seem that solicitors taking on these cases will I imagine, accept that whatever they're awarded by way of expenses, they will accept that. And if they're not awarded expenses, if they lose, then generally they will be covered by insurance or third-party litigation funders. And we anticipate that there will be a lot of interest by litigation funders. I think you're going to touch on that later. I think how quickly group proceedings can get underway is likely to depend on how quickly the pursuer firms who are looking to raise these actions and the litigation funders can get their act together. In theory, and I think in practice, litigation funders are going to be able to justify spending more money, using more resource in pursuing these claims where they see the return as being higher. So I do certainly envisage that we will see a larger number of cases being litigated in the Court of Session under group proceedings than we have up to now, but time will tell. I don't know, Craig, other countries obviously are well ahead of Scotland in this, and I know you've been looking at England and Wales and other jurisdictions. I mean, what's been their experience up to now in terms of numbers?
Yes, well, I think that the numbers in terms of our nearest neighbours in jurisdictional sense in England and Wales don't indicate that there's been a massive uptick in the number of matters proceeding by way of what is known as group litigation orders in England and Wales. So, for example, group litigation orders have been possible in England and Wales since about 1999 or 2000. And so it's been in operation there for 20 years before our own system, our own foray. Since the turn of the millennium, there's been 109 separate group litigation orders made. It's covered a vast and diverse range of topics and issues, ranging from unauthorised removal of organs post-mortem to the negligence of McDonald's in selling hot drinks. But that amounts to, on average, about 5 per year, 5 group litigation orders per year covering England and Wales, which is a far larger jurisdiction. So that would indicate perhaps that we're not likely to experience a tsunami of claims if our nearest neighbours are providing any context. A bit further afield, Australia has had the equivalent of group proceedings available in both federal and state courts for a number of decades before the English and Welsh jurisdiction. But over the last 30 years, for example, despite this process being in place for far longer, there's been an average of just over 20 class actions filed across Australia per year. So that's perhaps a little higher, and it's a smaller jurisdiction than England and Wales. But the comparator that is perhaps giving rise to assumptions that there might be a tsunami of claims is, of course, the United States, which is the longest experience of allowing claims to proceed by way of class action. And indeed, it's something very familiar to people who've watched movies coming out of America. But I haven't been able to find any particularly good estimate of the numbers of class actions proceeding in America, because its class actions are proceeding across all of the various states and also at a federal level. But for example, in the last year, there were 400 securities class actions alone proceeding. And that's obviously one very small element of the number of class actions that will proceed in America. So it's very much an industry in America, but there is 3 different comparators there as to how it's being approached in different jurisdictions. So my own view is that in terms of the international context, it will depend upon the uptake, both by pursuers, as you said, Joyce, by pursuers themselves becoming aware of the proceedings, pursuers firms actively looking to attract that type of work, and also the funders behind those individuals and firms.
And obviously they're pretty well established in the US.
Yes.
In terms of making the funding available for litigation of that sort. Yeah.
Yes, well, there'll be lawyers in America who will be specifically considering themselves class action lawyers, and that's all they will do, and they will focus upon attracting that type of work and taking those class actions forward. And it is a real skill. So that's the international context. And I suppose moving on then to the practical sense, or what steps can be taken practically, Joyce, if there are to be more actions raised against the range of organisations that you've highlighted, then what should these organisations do to prepare for either a tsunami or a trickle of group proceedings, whatever it turns out to be?
Well, there are a number of things that we've been recommending to clients that they should be thinking about, in advance of any group proceedings orders or intimations being made to them, because clearly this would be a significant event for an organisation of that sort, and preparation is really important if we are concerned about that. Insurance policies is the first one. Obviously, most businesses will have insurance in place for the sort of claims which they would have anticipated happening. Things go wrong in their organisation, most businesses will expect to have cover. But we are certainly recommending that people should look at their insurance policies carefully, thinking about the sort of claims that have been made in the past, and thinking about the claims that might be made under group proceedings, but for relatively small amounts, where perhaps the organisation has thought no need for insurance to cover that because they're relatively small, we could manage to sort them out through dispute resolution schemes that they run themselves. But where you're looking at very substantial numbers, then I would certainly recommend that speaking to your broker is a very wise thing to do at the beginning. Putting your insurance on notice, obviously always important. As soon as any claim is intimated, it's really important that you go to your broker or your insurer direct and tell them that you've received intimation of a potential claim. But I would say that because of the nature of group proceedings and the likelihood of the amount of work that's going to be required if you are served with group proceedings, that you should be engaging really very actively with your insurers as soon as you have any inkling of the likelihood of a group proceedings action being brought. And most insurers will be very familiar with this because of their cross-border experience, and they'll be able to assist individuals, companies who are going to be facing these. They will, of course, need some time to get up to speed with the new Scottish rules because there are significant differences between them. Engaging solicitors as soon as possible, well, we would say that, wouldn't we? But I do think that in this case, just as groups of pursuers are working with solicitors at an early stage and getting up to speed and arranging for these actions to be ready, it will be sensible for solicitors to be involved at an early stage to make sure that we have, counsel involved, that we know what's likely to happen, that we have arrangements in place to speak to the right people in an organisation if and when an action is actually raised. If there is no insurance in place, then considering after the event insurance, ATE insurance as it's known, is certainly something that organisations will want to think about getting. It's obviously more expensive than taking out insurance prior to the event, but it's certainly worth considering having. And I think organising your internal resource is a really important point. I would say this about any litigation, but I think even more important if you're likely to be faced with group litigation because of the range of investigation that might be required into individual claimants. So thinking about who in your organisation would lead if there was something of this sort happening, who will be the person that's going to choose solicitors and instruct solicitors, who will carry out investigations on the ground, what will the reporting line be internally and externally, who will be liaising with your regulators, if there is a regulator that's involved, if there's a suggestion that the claim issues any breach of the criminal law or professional obligations. It will be really important that these are thought about at an early stage and that arrangements are made within your organisation as to who is going to deal with each aspect of these. And finally, I'd say think about press and PR. Group proceedings are new in Scotland and they are likely to attract press attention. Think about in your organisation who's going to deal with PR, what can be said to the press if you're asked a question about a claim having been made, because it will be important not only that whatever you say in response to those sort of questions doesn't damage your organization's reputation, but also that it doesn't damage the defense that you're going to put forward. So it's very important that you work with your insurers, the lawyers who are involved, and people within your own organizations who are used to dealing with the press. Be prepared and make sure that you have something ready to say. And I say that specifically because unlike other types of cases where there might be some press interest only at the stage once the action is raised and something's been said publicly about the action. With this type of action, there's going to be press interest because there'll be advertisements going out asking for potential claimants to come forward. So people will be well aware of that. And you'll all have seen, in the press in the last year or going back further than that, adverts for people coming forward in relation to the purchase of cars. We've seen them for the Volkswagen claims that have been made. And that's because the rules require press advertisements to be made. So people are just much more aware. So those are the sort of things I would say you should be thinking about, not to be too depressing about it. We'll now, I think, make some time for questions. And we have quite a few questions up on our list at the moment. The first one, I have to say, is a rather difficult one. So I'll just be handing that straight over to Craig, which is, would it be competent for suppliers to put a clause in their terms and conditions preventing their customers from bringing group proceedings? Now, I have to say, I have not thought about this. Nobody's asked me that question before, but my immediate response to it would be it'd be very difficult to do that. I think that particularly from the consumer's perspective, the consumer protection legislation probably would prevent that anyway. But so far as the actual court rules are concerned, I can't really see that being a sort of preliminary point that would be made. The court rules, certainly it may be something that can be argued at a later stage in the action, but I don't think it would prevent group proceedings being brought as long as the claimants, the pursuers, were able to persuade the judge who's giving permission that the criteria that they're supposed to apply, so in other words, whether they had same, similar facts, etc., applied, and whether they were had a reasonable prospect of success. Having said that, if there was a clause which would prevent them from doing so, then I suppose you might argue that as a preliminary point. So I don't know the answer, but it's a very interesting question. I don't know, Craig, have you any view on that?
Yes, like yourself, I haven't considered it before. It's a good question. I think it would, my initial impression would be it'd be very difficult, because what you'd be seeking to do then is deprive not only the individuals that you're contracting with from joining together, but you'd be depriving the courts from efficiently conducting the matters which has been expressly provided for under the statute and the rules. So I think it would, if you did have, you could have a clause in there to that effect, but I don't think it would.
Might not be enforceable.
Yeah, there would also be challenges as to whether or not it was unfair if it was a consumer-facing provision to that effect. And they hadn't taken any legal advice. But I don't think that you could stymie the courts from efficiently conducting matters by way of the statute and the rules as set out and as we've discussed. But yeah, an interesting point.
Yeah. Another slightly different question that's been raised about press interest and whether how would the press know about a case. Clearly, there's the possibility of the press looking at what we call the rules of court to see if an action's been raised in that way. Is there any other way that individuals or the press could watch these hearings, particularly now that we're working basically in virtual courts, or have been in the past few months?
Yes, well, I suppose in terms of where we're at the moment, there's intentions from a number of parties to go forward with group proceedings, but I don't understand that any group proceedings have yet been granted yet. There's been a number of hearings before calling. They've been held remotely, and as I understand it, interested parties can apply to the Scottish Court and Tribunal Services to have a link to the WebEx. In terms of knowing about whether or not it's going to go ahead, like you said, there'll be court rules, but obviously, as set out in the rules. If you want to go ahead with group proceedings, you have to advertise it to the public to attract the attention of all possible members of the group. So that will by necessity be going out either on radio or TV or on the press. So the press will very quickly pick up on it. And the pursuers firms won't be shy in trying to hide the fact that they're looking to get people to join the group. So they will become aware of it. Most of the press have fairly good relations with the teams that organise the rules, and we'll find out if there's anything interesting coming up. And they, as well as other members of the public, are just as entitled to sit in and see justice being done.
Yeah.
So yeah, they can find out about it, unless it's a closed hearing, which I don't think would be the intention of the courts.
There's nothing in the rules that would allow anything special about group proceedings for privacy purposes. No. I suppose there would be the same opportunity as there is in any other commercial action if there was a particular reason for a hearing to be, a particular part of proceedings to be kept private for, business confidentiality or something. But it's quite a hard test, isn't it? So, I mean, generally, I think we would have to assume that these proceedings would be in the public domain, just as people can walk in and sit at the back of a court now. As you say, they can get a link to court proceedings and watch them online if they want to.
Yes, justice being done.
Justice being done, absolutely. Another couple of questions have arisen about the difference or what we might take from other jurisdictions, if you like. Scotland and England are obviously the closest ones. Is there any particular difference between our types of rules and the rules that are in England that would mean that we can't simply copy or take from what's happened in England and apply it in Scotland?
I suppose one aspect of the English equivalent proceedings is that it needn't be that the pursuer's grouping moves to be considered as part of a group litigation order. The courts in England can, of their own volition, effectively combine cases to be determined, and that's not something that the rules that are currently in place in Scotland anticipate. That this has to go through has to be positively advanced by the group themselves. Albeit we're all aware of the way that the court has tried to, for reasons of administration of justice and efficiency of that administration, as you'd mentioned earlier, Joyce, has sought to combine certain cases that are similar. For example, the vaginal mesh cases and the Watling Street cases were combined administratively by way of a direction from the court. But that was just in terms of efficiency and ensuring the smooth progress of these cases before the courts. But I imagine that the court might give a fairly heavy hint if matters were proceeding individually, that parties might want to discuss matters to see whether or not these might be more efficiently dealt with by way of a group proceeding. But as I understand it at the moment, one key difference between England, Wales and Scotland is that the court couldn't simply just set up a group proceeding of its own volition, unlike in England and Wales.
And I suppose looking at the rules, that might be quite complicated for a judge to do here, because applications have to be made, and the judge can't make the application on behalf of the pursuers.
It's quite a heavy onus upon the representative party in relation to the maintenance of the group register, and also ensuring advertisement and the upkeep of the register. So someone couldn't have that thrust upon them without actually willingly making that application.
I suppose there could be a heavy hint, as you say, just in the same way as sometimes judges give heavy hints about perhaps you'd like to go away and discuss settling this, or having a mediation or something of that sort. But they couldn't enforce that. Yeah. And I think actually there's a sort of linked question, I suppose, as to the influence from other jurisdictions such as Australia or the US to give any indication of what a court might consider is good prospects of success. Although I think the test here is any reasonable prospect. Am I right?
I think real prospect.
Any real prospect. I'm sorry. Yeah.
And as you said earlier, Joyce, that is a stiff test, and it's one that will be keenly in the interest, or looked at keenly by the judge considering the application, because it's not only that you've got a prima facie case, but you've got this extra.
Yeah, it's a sort of double test, isn't it? Yeah.
And In terms of the international context, I must admit that there will be that the phrase real prospects will have a common sense meaning, but I don't know if the courts in Scotland will automatically look out with their own jurisdiction for interpretation of that in this context, because each of the other jurisdictions will be dealing with different wording, albeit trying to filter the cases that go forward, taking account of prospects, but they'll probably use their own wording. But ultimately, real prospects has application across a number of different considerations in civil litigation. It's something that's going to have to be faced up, and there will be cases that will test it, no doubt.
Yeah, I can see that. Yeah, and I suppose actually there's a follow-up question which kind of relates to the point we've just been talking about, as these sort of preliminary arguments that might be taken to stymie the whole process. And it's actually a follow-up question from the earlier one about, even if you couldn't put in a clause that prevented, say, customers from bringing group proceedings because it's in your contract. I'm trying to envisage what that would be. Maybe someone checking into a hotel signs a contract to say that they won't bring them. And similarly, if you were to sign up as part of your contract, say as a supplier, to say that you would go to arbitration rather than to court. Now, I suppose if group proceedings were to be brought by a whole group of people who had all signed up to that contract, would the court be able to look at that at the outset and say, as they would in normal commercial actions, no, you've agreed to go to arbitration here, therefore we'll have to cease the action, put it on hold until the arbitration proceedings have gone through? Again, I haven't thought about this as a possibility, but what do you think?
No, I think it's a great question. As we all know, the court is very keen to ensure the integrity of the arbitration process. And so that if there are arbitration provisions in a contract, standalone contract, the court will give, will obviously have to be addressed upon that. But if addressed upon it, then it will ensure that the matter proceeds as intended, i.e. through the arbitration process. Most of these contracts have arbitration as a first step, and if matters can't be resolved, or there are issues that require to be explored outside of the arbitration, that be referred up to the court. But so on the hypothesis put forward, what we're anticipating here is if there are a number of contracts with individuals who could have joined together to raise court actions, I think that what would happen is that they would apply for group proceedings, and then would have to be addressed on the fact that the contract relates to one, or the contract surrounding the issue is one which has dispute resolution procedures, including, for example, arbitration, which would have to be exhausted first. Now, the court would probably have to be alive to that in the same way as they would do in any other case where it's sought to be addressed. But I think that the court would also have to be alive to the fact that, well, they will have to be dealt with as efficiently as they could be dealt with by way of group proceedings in the courts. And if they were being deprived of the opportunity to do that, then that would be a factor that would be considered by the court as to whether or not the group proceedings were assisted.
Yes.
Because I suppose that would be what would be happening. You'd be considering it at the point in time the action was live, and you'd be looking for it to be assisted pending the exhausting of the arbitration, etc.
And of course, as you said, and I think the rules make very clear, the judge who's in charge of this case has got very wide discretion about how to manage the case. And I suppose one of the things could be, even if he said, yes, this is a suitable case for group proceedings, but I'm putting it on hold just now, there would be very little that you could do about that if everybody had signed up to it. Okay, well, I'm conscious we're getting very close to time. There's just one final question, I think, which is on a different issue, is about from the pursuer's perspective, the question of cost and fees. Is it going to be much better for claimants to bring this type of claim because the risk is lower? What would you think, Craig?
Well, I give the usual lawyer's answer that it depends.
It depends. Yeah.
But I can see it being quite attractive to some larger organisations, stroke insurers, who might be quite keen that all of these matters, all of these disputes are dealt with in the one forum, and so that it's clean, and you will be faced with probably a larger account of expenses than you would be dealing with it if one action was to go through. You might anticipate that you'll be facing an additional fee due to the elements that will naturally come with dealing with a group proceeding. But what they'd be mindful of is that if all of these actions went through individually, they'd be facing individual accounts of expenses in each case.
Yeah.
I can see that being an attraction. Looking at it from the other direction, what we'd have to anticipate is that if these were all fairly low value claims, they would be mindful that all of them may not be advanced individually because it wouldn't be worth their while, or they hadn't actually realised without this advertisement of group proceedings that they should raise a claim.
Yeah. So it could be an access to justice benefit. I suppose is the
certainly it's got that benefit. Yes.
Yeah. Yeah. Okay. Well, I'm conscious that we've slightly run over our time. Can I say again to all our participants, thank you very much for joining us. The slides and the recording will be available if you'd like it. And if you have any follow-up questions, please do get in touch with myself or with Craig. Our contact details are there for you, and we're very happy to have a chat about any concerns that you might have on this area. But I can say thank you very much for joining us, and do